Hello friends, today we will be discussing about criminal responsibility and the laws that deals with the criminal responsibility of a mentally ill person. So, let us talk about criminal responsibility. Before that, before law, the law presumes that every person has a sound mind and every crime will be having a criminal intent that is called mens rea. So, two things the law presumes. First one, every person will be having a sound mind, and every criminal activity will be having a criminal intent that is called mens rea. These these two things has to be proved by the accused whether it is not present. So, if a person is having an unsound mind or there is no criminal intention behind the activity, the burden of proof of unsound mind and not having a mens rea will be on the accused. That is the first concept we have to understand regarding the law. Now, what are the laws that deals with the criminal responsibility of mental person? The first one is McNaughten's rule. It was formulated in 1843 and it is incorporated into section 22 of BNS Bharatiya Nyaya Samhita. That is the first rule. Then there are other rules that is not applicable in India but in other countries. That include first one that was introduced was Durham's rule in 1954. Then it was replaced by Curren's rule in 1961. Then along with that there is American Law Institute test and irresistible impulse test. These are the main rules we are going to deal today. Along with that, we will be talking about the doctrine of reduced or diminished responsibility. So, coming to McNaughten's rule. McNaughten's rule formulated in 1843 was done why? It was introduced for what purpose? So, there is a story regarding that. There is an incident regarding that. Daniel McNaughten was a person who is having delusion of persecution, that the prime minister of that time, Sir Robert Peel, was planning to do some harm to him. There was a delusion of persecution. So he killed the personal secretary of the prime minister, mistaken for him, under the delusion of persecution. And in the court, for handling this case, McNaughten's rule was introduced. And it is incorporated into section 22 of BNS, and it states that McNaughten's rule per se states that nothing is an offense which is done by a person who at the time of doing it by the reason of unsoundness of mind is incapable of knowing the nature of the act, or that he is doing either wrong or contrary to the law of the land. That is under section 22 of BNS. McNaughten's rule is being incorporated. Now, when we look here, we can see there must be four components, four important things that is mentioned in this definition. First thing, unsoundness at time of committing the act, not after doing the act, not before. At the time of committing the act, there must be unsoundness. First thing. Second thing, he must not know the nature and quality of the act. Second thing, due to the unsoundness of mind, he should not know the nature and the quality of the act. And third thing, even if he know the nature and quality of the act, he must not know it is contrary to the law. That's the third thing. Even if he know the nature and quality of the act, he must not know it is contrary to the law of the land. And finally, he should not know whether it is right or wrong. These four things are the main components in the definition of the McNaughten's rule. And these four things regarding to the law is confirmed by the legal test of insanity, in which the defense has to prove that the person is not having a criminal intent or mens rea while doing the act. And this legal test of insanity is a burden on the accused. The accused or the defense must prove that there is these four things, these things are there. Now, is there any limitation for this law? Yes, there is the limitation. First thing, it is called stubborn law, because it's an all or none law. If a person is applicable for this thing, that is only in case of severe mental illness. No scope of application of this law for moderate or mild mental illnesses, only for severe mental illness. And if the person is held criminally responsible, he is getting full punishment. And if he is getting the benefit of this section 22 of BNS, then he will not be criminally responsible. So it is an all or none law. Second thing, the act of person is subjected to the legal test, and because of this, not all cases of mental illness will not get this benefit of section 22 of BNS. That's why it is called stubborn law. Two things. First one, it is all or none law, and it can be the person is undergoing the legal test, so not all mental illness patients will not get the benefit. That's about McNaughten's rule. Coming to the other laws that is not present in India but in other countries. First one that was introduced was Durham's rule. In 1954, it states that an accused person is not criminally responsible if his unlawful act is product of his mental defect or disease. But this has a limitation because this is more generous towards the accused person, and a person without mental illness can produce a certificate to get the benefit of mental illness. So, taking into consideration of this limitation, it was replaced by Curren's rule in 1961. It states that an accused person is not criminally responsible if at the time of committing the act, as a result of the mental disease or defect, he lacked the substantial capacity to conform his conduct to the requirements of the law. So here there is the at the time of committing the act, and here it is added that he lacked the substantial capacity to conform his conduct to the requirements of the law. That is, he does not know that it is contrary to the law of land. So this is the modification made in the Currens rule. Then American Law Institute test, also known as ALI test, is some more modifications in Currens rule. That is, it states that a person is not responsible for criminal conduct if at the time of such conduct, as a result of mental disease or defect, he lacks a substantial capacity to appreciate the criminality of the conduct or to conform his conduct to the requirements of the law. So, in case of ALI test, the only addition that is made is that to appreciate the criminality of the conduct, and remaining all is similar to the Durhams, similar to the Currens rule. Now, next one is an called irresistible impulse test. It is also known as New Hampshire Doctrine. Okay, it states that an accused person is not criminally responsible even if he knows the nature and quality of the act and knows that it is wrong if he is incapable of restraining himself from committing the act due to the mental illness. Is simple, an accused person not criminally responsible if he is incapable of restraining himself from the act due to the mental illness, and this doesn't matter if he knows the nature of and quality of the act, like that. And this can be very useful. This will be beneficial for the psychopaths who has the irresistible desire or impulse to do the crime. They will get the benefit. Next thing is the doctrine of diminished responsibility. This is applicable in case of minor degrees or in case of moderate or mild mental illnesses. It recognizes that the mental illness are of different degrees, and in minor degrees of mental illness, the person is not held fully responsible for his crime, but he is held partially responsible. That is the doctrine of diminished responsibility. And according to section 22 of BNS, severe cases of mental illness are considered to be getting the benefits, and the person with mild and moderate degree of the mental illness will not get the benefit. That is one of the limitations that we have said in case of section 22 of BNS. That is an all or none law or step-bound law. Okay, because it is not accepting the doctrine of diminished responsibility. So this is about the class. So we dealt about the criminal responsibility, what the court presumes, then various laws, McNaughten's rule, Durham's rule, then Curren's rule, then American Law Institute test, Irresistible impulse test, or uh, New Hampshire doctrine, and the doctrine of diminished responsibility.